Good morning, sir. You're Jerry Dickert.
Yes, ma'am.
And Mr. Dickert, did you get a lawyer hired?
I haven't hired one. I've talked to three. I don't know if you received my email. I don't have a vehicle. Had one repossessed and one stolen.
Who'd you talk to? What
I
lawyers?
talked to there are three Houston firms, a Martinez law firm that gave me their payment plans and the estimated cost based on my cases. Huff Law Firm in Houston and Dunbar and Jones. And I've also looked into something called case funders that will allow me to borrow the money to pay for an attorney.
Do you, thank you for doing what I asked you to do. Do you want to fill out the paperwork this morning to see if you qualify for a court-appointed lawyer? Or do you want to see if you get that money and hire your own with one more reset?
I'm living on unemployment right now, which is about $1,000 every 2 weeks. But I'm embarrassed.
It's okay. I just need to know if you want to fill out the paperwork this
Yes.
morning or if you want to get 30 more days to try to hire someone.
If I could have 30 more days, I would appreciate that because I think I can get a vehicle and get a job.
I'll reset you one more time, and then if you make sure you talk to some other attorneys, bring back any information you have with regard to if you've gotten a job, and then we'll see what your options are if you don't have someone. Step in front of the clerk, please.
Thank you very much.
Yes, sir. Sir, is it McIntosh or Tosh? McIntosh, you're Vernon McIntosh. Mr. McIntosh, this is your initial appearance in cause number 26 DCCR 1090. You're charged with the third-degree felony offense of failure to comply with sex offender registration requirements from May 20th of 2026. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
I called one of Elaine Walker.
Uh-huh.
He wrote $10,000, and I'm gonna be looking for somebody else.
So what I'll do then, Mr. McIntosh, is reset your case about 30 days or so to give you some time to see if you can get someone hired. If you get someone hired before that next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do.
And can I ask you a question?
What's that?
I know I've been registered since 18, and I know it's a lifetime. Is there any steps that I can go through that I was looking up online that I can possibly get
You're
off
gonna
the
have to talk,
registration?
you're gonna have to talk to a lawyer about that.
Okay.
So let's get through the case first, and the lawyer you get, also talk to them about that. There may be some options for that, but that's not something that I'm not allowed to give legal advice.
Okay.
So if you get someone hired, again, bring that reset notice to them. If for some reason you don't get someone hired, make sure you talk to at least three. Bring me back those names so I know who you've talked to and we'll discuss your options.
Yes.
Okay, step in front of the clerk. She'll give you a reset notice. Morning, you're Lisa Pratt.
Good morning.
And this is 24 DCCR 1460. Ms. Pratt's charged with theft of property with previous convictions. And what's the announcement?
Your Honor, I believe we have a deal worked out. I would respectfully ask the court, depending on what the court wants to do. Did you see her put she has one more doctor's appointment? We can either plea today, and I would respectfully ask for sentencing without a PSI to be set maybe 30 days, or we could reset it for a plea, but
Oh,
That's
is
where-
the agreement for some kind of time?
12.
What I'd like to do while you're here is go ahead and we can do the plea and I'll reset it without the pre-sentence report. And then we can set a sentencing date based around a typical time for a PSI is about 45 days. If that gives her time for that last appointment, we can do that.
Yes, sir.
Okay, I'll hold it while y'all take care of that paperwork.
Yes, sir.
So, Mr. Patterson, you tested positive for THC. There's no reason you should have tested positive if you had stopped using before when you were in court last time. So obviously you're not doing what you're supposed to be doing with the drug patch and staying clean. So you give me no choice at this time but to raise your bond in your case. Let's see, what does it say that name? Current is set at $7,000 and give me a second to look at this. I'm going to raise your bond in your case to $25,000. Condition of that bond obviously is going to be that you have a drug patch on, but you can't, it's not just a matter of going and getting a drug patch. It's getting it changed every 2 weeks and it's the drug patch being negative and you staying negative. So if you make that bond, obviously you cannot use anything that has any type of THC that would test positive, legal or not legal. And you have to have the drug patch on within 24 hours of your release from custody. You can go back with the bailiff. Good morning, sir. Are you Dan Church?
Yes, ma'am.
And this is 26 DCCR 0612. Mr. Church is charged with deadly conduct, discharging a firearm, and what is the announcement?
Judge, we're still working on this case. We've been here in one setting about a bond issue, which I think we've got sorted out. But
Right.
other than that, we're still working through the discovery. I think that was only a couple of weeks ago. We're still working through it. I'd ask for a normal resetting on this,
Any
so he and I
issues?
could discuss.
Sure.
I have no issues with that, Your Honor. I have an offer that I can tender to counsel at the appropriate time. I would like the record to reflect that since that bond hearing, I have asked Ms. Tanner, and she kindly sent me the transcript of that, just so we could all be on the same page with regard to that. There have been no issues brought to my attention, and so we can just keep everything as is. I think hopefully we'll be able to resolve this.
Perfect. Thank you. All right, we'll just do a normal reset. Mr. Church, make sure you stay in touch with Mr. Kurtz so you can visit with him before that next court date.
Thank you.
You're free to go, sir.
Good.
Mr. Gover, in cause number 24, DCCR 0512, you're charged with the second-degree felony offense of attempting to commit sexual performance by a child from August 2nd of 2023. And how do you plead to that charge?
Yes,
Are you pleading guilty freely and voluntarily?
yes, ma'am.
And because you did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Ms. Busick?
Yeah.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 10-year deferred probation. There would be a $2,500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1. Any objection?
No objection.
It's admitted. Is there any evidence that Mr. Gobert is not competent?
No.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's at that desk right behind you. So stop and talk to her on your way out, and then we'll see you back at sentencing.
Yes, ma'am.
Nice to meet you. Thank you.
Thank you. You as well.
And we're going on a lesser, looks like. Of
Yes, just a straight evade.
Good morning, ma'am. Are you Evelyn Odom?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
So wait.
Ms. Odom, in cause number 26, DCCR 0403, the state has elected to proceed on the lesser included offense of a Class A misdemeanor evading arrest or detention, and that is from February 8th of 2026. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimler?
Yes.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
And it's for 30 days in jail that would be sentenced today. Is that correct?
Well, she has a job. Explain to the judge.
Well, I mean, I just got a job. It's really hard for me to get a job, I guess, because of my age. And so I really would like to put in 2 week notice. It's for CalCam. It's like just flagging in the parking lot. It's $15 an hour. And so I've been looking for a job for a month. So if I put in a 2 week notice, then maybe they would hire me back. I mean, just because I haven't done that.
Okay, so we just need to reset for sentencing for 2 weeks. Okay.
You don't show up.
I'm coming out with you here.
Well, I'll go through that with you in just a second. So it's for a 30-day jail term, and are you a U.S. citizen?
Yes.
State tenders number 1. It's admitted. Is there any evidence that Ms. Odom's not competent?
In court, time is everything, and sometimes it's the only thing standing between you and serious consequences. In this case, the defendant asked for just 30 more days, hoping to get his life together and hire a lawyer. The judge agreed, but made it clear this was the final opportunity. Meanwhile, others in the courtroom weren't as fortunate From a bond jumping to $25,000 after a failed drug test to guilty pleas leading to jail time and probation. This is how quickly things can change inside a courtroom. One decision, one mistake, or one delay can shift everything. The judge isn't just listening, she's watching every move. And when that final chance runs out, there are no more resets.